Hi, this is Rahul Reddy. We are here live from Houston, Texas. Along with me is Emily Neumann. Emily?
Thanks for joining us this week. We're always happy to bring you the latest updates on immigration and, as always, answer your questions. This week we want to talk about social media. As you probably already know, it is a new question that is already on the DS-160 application form. It is in the works to be added to other applications such as the I-485 and the N-400 application form. That's not final yet, it's just a proposal. But we often, as immigration attorneys, will see issues that could have been avoided by the way that the social media is being done and what you're putting out there in the public on your account. So we want to talk about that. Wanted to discuss the employment-based EB 2, 3 priority dates, EB1 even,
EB1,
as that's
EB1 too.
Awful too. What to expect with that? Why are they not moving? We still don't even have the October visa bulletin, which is unusual for this late in September. We get a lot of questions also about investing for non-immigrants, and so we want to give you some information about types of investments that might be okay and others that you should avoid. And lastly, we want to talk about automatic revalidation. It's a great tool that can allow you sometimes to use an expired visa to travel into the country from Canada or Mexico in certain situations, and you may even be able to use a visa that was actually valid in a different category if you received a change of status. So we'll talk about that.
And we're first getting into the social media. And what are the common things do you see where our clients do mistake? And they get into trouble with immigration, CBP, and different branches of government.
Yeah, I think most commonly issues on LinkedIn related to employment history and issues on Facebook related to family marital status.
And sometimes even employment too.
Yeah, unemployment there, yeah. So, we see that a lot for people that are working as a consultant at an end client. On LinkedIn, they'll list the end client as their employer. Well, when you're filing an H-1B petition, it's very important that your actual employer, your H-1B sponsor, be your actual employer and is the one with the employer-employee relationship and is supervising you and meeting all of the requirements. But then you're, hanging out with your information there, making it sound like you're actually an employee of the end client, which could be problematic when a consular officer Googles your name and finds you on LinkedIn, or CBP officer, or even a USCIS officer. And then the other issue with marital status, I think that we've seen situations where people, are not holding themselves out to be married yet applying for a dependent visa, such as an H-4 at the consulate, and that's caused some trouble. Do you have any other?
The common things are, we've been looking into the social media even before the social media came up with the DS-160 form. We always used to advise people that the consulates are looking at, the government is looking at your social media. The common mistakes that I see, the number one is that people do not list their employer on their social media. They do list anybody else but their employer. So if ABC Consulting Company is the company that you're employed with, they are the person who hired you, they are the person who can fire you, they are the person who are paying you. That is your employer. That employer should be listed on your social media. If you don't want to list any of your employer, like in Facebook or so, that's fine. You don't have to list any employer. But if you are listing it, it should only be your employer that should be listed, not the end client who is not paying you the salary. Do not list that, that will get into trouble. This is one thing. If by any chance on your LinkedIn or anywhere else, Facebook or any of the social media, you do have information of the companies that you did not work with, companies you did not have authorization to work with. We have seen a lot of problem in people when they are coming into the United States. The CBP does check those things, Customs and Border Protection secrets. We also noticed that even though WhatsApp is not one of the social media that you listed out and the DS-160, if you have any information on there that suggests that you're not actually working for that company, or if you're not authorized to work and the WhatsApp is suggesting that you are probably working somewhere else. We have seen people that got deported from the airport many times So if you have any information, you may want to check, contrary information, you may want to check with your legal advisor before you do any entry into the country. Try to make sure that your social media is completely clean, and you know what that means. I mean, if the immigration is complying with it, your employer is a proper employer, your marital status is properly reflecting, any information, that's fine. I mean, if you have a social opinion on a political opinion, whether Trump administration is good, Trump administration, you disagree with it, or your home country thing, we haven't seen any much problem on that. It's just your marriage information, your employment information is where we're concerned about.
What do you think is on tap for priority dates in updating the visa
That's
bulletin?
surprising. In the past 23, 25 years, I've been noticing priority dates since the time I got my green card in 1996. I haven't noticed this delay. Normally, the priority dates will be coming between 9 and 13. There are sometimes the delay occurred, especially in June of 2007, where they issued 2 visa bulletins, and in September of 2015 they have issued 2 visa bulletins. But getting to 17th at this point of time, I don't know. It's like, is there anything good coming out? I don't know. Per country quota is definitely not removed at this point of time. So don't expect that in this visa bulletin you're going to see some miracles on the per country quota limit. But we yet don't know. I do think so that nothing bad can happen. I mean, it's 2009 and 2010 is a priority date. What bad can happen to the already people there? I mean, are they going to go to 2001, 2006? I don't think so. Anything bad can happen to the backlog nations, though. It's only something good, maybe there, I don't know, or may not be there. But nothing bad can be. They're already in worse. They're already in big soup. What can you do? What damage can they do to the backlog nations? But yeah, certainly it's creating some eyebrows. Why is it taking a long time? Normally between 9 to 13 is in the month of the 9th to 13th is where we are supposed to get the visa bulletin, and this is 17. I even checked the Philippines consulate. Sometimes they do release 6 hours before the visa state visa bulletin. I have checked that too just before I came into this one, into this Facebook Live and YouTube Live. I haven't seen anything there too. But yeah, don't expect any miracles. If there is any movements, it's going to be very slight movements. Not much movements are expected in the EB1, EB2, and EB3.
Yeah, I think the best we can hope for is maybe a favorable filing dates chart,
Right.
and maybe we'll be allowed to use it.
Right.
October is typically the time frame since they created that chart in 2015 when we've been able to use it. So I think that's our best hope for
And then
anything
October
positive.
1st is also the new year for the immigration. The quota starts from October 1st, ends on September 3rd. So October 1st is a new year. So let's see if some good thing comes out, Emily. On the issue of the investment options, Emily, people are here now and the green card is taking forever. Some of the people, they love the country and they want to stay in this country. They want to invest in this country. And they are on the non-immigrant visas. What restrictions do they have? Can they buy their home to live in, or they cannot?
Yeah, I think that yes, you can, but you've got to be very careful about it because you don't want to be in a situation where you've just bought a $500,000 home and then your H-1B extension gets denied, and you have to leave the country and figure out who's going to be taking care of your home while you're outside the country trying to work that out. So there's definitely risk there, but there's nothing stopping you legally from purchasing a home. What do you think about investing in the stock market?
Investing in the stock market is absolutely not a problem as far as the legalities is concerned. I'm not going to speak about we are not investment advisors, guys. We're just immigration lawyers. So please don't take any of our advisors as an investment advisor. As far as the stock market is concerned, I don't see any problem in people investing in stock market. If they're trading in the stock market, that's not considered as working. Any profit that you make, you are supposed to pay the taxes on it. But as such, you are fine. We don't see any problem in investing in the stock market. Emily, on the rental properties, where is the gray line, where is the black and where is the white line on when people want to invest in the rental properties?
Yeah, I think that on the one end, you purchase a small rental house and you find a tenant and you rent it out, and someone else takes care of the repairs and someone else takes care of the lease agreement and collecting the rent and all of that. To me, that's very clear that there's no issue with status. The opposite end of that is you're basically a property manager and you have maybe 10 different rental units and you're the one that's going out and getting them leased. You're doing the repairs, you're collecting the rent and all of that. That gets more onto the side of maybe that's work without authorization. So I definitely lean towards the earlier end on that, and not get too involved in the day-to-day operations, especially if you're creating a separate legal entity, creating a company that's going to be the shell for all of these rental properties. That gets into the potential where you're working without authorization.
Emily, on the middle path is the gray path where I do have 3 or 4 properties. I'm on a H-1B. Is that allowed?
I mean, I think it depends on what you're doing. If they're just sitting there and you're just collecting the rent every month, I think that's fine. But if you're the one that has to actively go out and find the tenants, and you're the one that's going door to door to collect their rent every month, and you're the one that's doing all of the repairs, now it seems more like you are a business owner and you are potentially doing work that you're not authorized to do on an H-1B.
Okay, so what about investing in a restaurant, Emily? Is that legal?
I think that you are likely to get into trouble with it because it's very unlikely that all you're going to do is hand over your money and walk away and not be involved. So if you're involved in the operations of the restaurant, if you're going there, if you are signing checks, if you're going to the bank, taking payments to the bank, hiring the chef, anything beyond just giving them your money and walking away, I think that
I think so. If you're investing in a restaurant, I would recommend them to contact an immigration lawyer. Most of the time, even though, Emily, they do say that they are not involved in the management, and when I see the lawsuit filed on them are because of some default of the loan or maybe a fire or whatever it is, and I always see that they're already there. They signed the checks, they have done the activities, they're being put as a defendant in there. So a lot of times I see a lot of problems in the restaurant investment. I normally recommend people to consult a lawyer before you do any restaurant investment, though. Emily, what about on the any other investments, like for example, business? Can they start their own consulting company?
Yeah, I think that's definitely going to be a problem. Anything beyond, the only thing that a non-immigrant worker can do is work for the company that sponsored you and the job that you've been sponsored for, and then passive investment on the side. Passive meaning you put your money there, let other people take care of the business, you have no control over it, and if you get a profit, you report that profit, and that's it, nothing more than that. But I think that someone who is starting a company, it's very likely that you're going to be the one opening the bank account. You're going to be the one signing the checks. You're signing contracts. You're reviewing invoices. You're doing more than just passive investment, and so I think it's going to be a problem.
Okay, Emily, on the automatic revalidation, what is an automatic revalidation? Do you mean to say that if I don't have the visa stamping valid in my passport, let's say for example, I came here to USA on F1 visa. Now I move to the H1 visa. Even if I don't have a stamping, I can go to Cancun and spend with my family and come back without a visa?
Right. That's the great thing about automatic revalidation. If you're going to be in Canada or Mexico only for less than 30 days and you do not apply for a visa stamp, you can use your existing F1 visa stamp to enter the country along with your H-1B approval notice, and they will automatically revalidate your F1 visa and pretend that for that moment it's changed to an H-1B visa and has not expired, and allow you to enter the country. So it's only Canada or Mexico, only if you don't go for visa stamping. So this doesn't work if you go for visa stamping and get denied and you think you're going to use revalidation to get back in. That's not the case.
So if they want to go to their home country, India or probably England, the revalidation is not applicable.
Correct. It's only Canada or Mexico. And it also works if you are have an expired H-1B visa, but you have a valid I-797 with an I-94 that's given you an extension, they will revalidate your H-1B visa stamp as if it's still valid on the day you're entering. Same thing for H-4. So it can be very helpful if you, for some reason, need to make a short trip to Canada or Mexico.
So what if I apply for the visa? Well, let's say I'm an F1, I went to Canada or Mexico, applied for H-1B. And can I still come back on the previous F1 even though I don't get the H-1B?
No, so that's one of the requirements is you cannot apply for the visa at the consulate during those 30 days while you're there.
There are a couple of other countries that also are applicable, are called adjacent countries, that are Dominican Republic, the Bermuda, the Bahamas, Jamaica, but I would want you to be careful. But in general, I would say if you go to Mexico and Canada, you can. But there are some other countries, if you want to look into the list of the countries where you can go and come back, you can always check at RN Law Group, automatic revalidation, the list of the countries are listed here. These are some of the countries where the cruise ships does take you there. So I want you to check the countries before you go in there. Just for the people to be aware of, Puerto Rico and Hawaii are considered to be United States. They are United States country. So if you're going to Puerto Rico and Hawaii, I mean, you're going within the same country. It's like a person traveling from California to Texas, the same thing. However, if by any chance you're going to Hawaii, but you're routing through Canada or some other country, then it's not applicable. You may want to check your validity. Emily, what other times do you use the automatic revalidation? Not just for them to go and have fun. There are sometimes you use automatic revalidation when the I-94 mismatch is there, when you want to move them from H1 to H4 without going through all the stress of the change of status. What are those timings that you use though?
Yeah, I think that it can be useful in the situation where you have, let's say you're in H4 and you have your H4 EAD and your employer filed an H1B for you, and you get that H1B approved, but you actually want to be back in H4 status. You could potentially use it to go out and come back in to kind of undo that status change without needing a new H4 stamp if your H4 stamp has expired. It also can be used to kind of clear up some potential issues with, like you mentioned, an I-94 mismatch. So that happens when you filed an application with USCIS, maybe it's an extension or a transfer. When you do that, you're going to submit your I-94, which has a specific number on it. While that's pending, if for some reason you travel and come back into the country, at the port of entry, you're going to be given a different I-94 number. Yet your extension or whatever you filed is still pending. When it gets approved, it's going to have your old number on it. And that can create issues with Social Security when you're trying to go there, when you're trying to renew your driver's license. E-Verify can cause some headaches. So you can solve that type of situation by traveling one more time for a quick trip to Canada or Mexico. Come back in, you'll get another I-94 number, and you can do that even if your visa stamp has expired or is in a different status.
Let's go to Q&As, Emily.
All right.
I have this question. Will the per country quota will be taken off? This question comes from YouTube. Per country quota need to be routed through the Congress. At this point of time, the House of Representatives, that is the lower house, has already passed the HR bill, and it's right now in the Senate. So Senate need to pass this bill, but there is a block on that at this point of time. So unless that block is removed, it's not going to come for voting. So that's the only way to get the per country limit off. At this point of time, the Senate is not giving that much importance to this bill. We'll update you if there is any importance that comes in.
Shubham from Facebook has a good question that comes up quite a bit. Already has a valid visa stamp until January 2021 with his current employer, and has now transferred to a new employer, received a new I-797 approval notice, and wants to know if he can travel and use the old employer's visa stamp that hasn't expired and still come into the U.S. And the answer is yes. The visa stamp is not tied to a specific employer, it's tied to your status, and it's valid until it expires. So you can use that old visa stamp that has not expired, even though it has the old employer's petition number and name on it, to enter with your new employer's approval notice.
Question that comes from Sandeep from YouTube is that, can I hold a business credit card when I don't have actively any business? Well, if you're working for a company and they give you a business credit card, we don't see any problem with that at all. However, you are just holding a business credit card. What did you list? You have a business in the credit card information. We're much worried about what did you listed in there. That may be questioned. That if you listed that you own a business in United States, and now that may become a problem at a later date. So I would want to be careful on owning a business credit card.
Sriram has a question for you. If you're entering into the into the U.S. and CBP is asking you to turn over your phone and read your WhatsApp, can you tell them that that's a violation of the Constitution?
I don't think so. You have the rights there because the Constitution is very limited at the time when you are traveling in the international. The Constitution doesn't give any fundamental right in doing an international travel. For the non-immigrant visa people, the rights are very limited, especially of turning over the phone and giving the WhatsApp that practically don't exist at all. For the US citizens though, they may refuse to give, and the CBP can get the permission from the judicial authority to open it up. But for the non-immigrant visa people, there's very limited right. You may not have any right on that at all.
All right, Raghu from YouTube is planning to travel and needs to get the H-1B visa stamp and has a U.S. citizen child, wants to know if having a U.S. citizen child could cause any issue with the H-1B visa stamping. No, the H-1B is one of the few visas that allows for dual intent. And so you can have the intention to be coming to the U.S. temporarily on the H-1B, but also have the permanent intention to stay in the U.S. because obviously you have a U.S. citizen child and likely are going to be sponsored for the green card either through your employer or possibly through your child in 20 years. But there should not be any issue with the H-1B visa stamping in that situation.
Emily, I want your attention on this one. YouTube, Nikhil has this question. Can he had 4 or 5 more job duties when he's responding to the RFE to the H-1B that he has? I think so. It's not about adding, it's about explaining the existing job duties that he has, is what I'm thinking.
Mm-hmm. Yeah, it's a very fine line to walk. And so, when you add additional job duties that were not in the original petition and you're responding back, you risk USCIS saying, wait, now you're saying the job is different than what you said before. You can't make a material change to the terms and conditions of employment after filing. They could deny for that. So you have to be very careful about how it's done. And what I typically do is I list all of the previously submitted job duties one by one, and then I expand on each of those to show what additional duties each of those contains. So that way you're not adding new job duties, you're expanding on what was previously submitted because that's what they're asking for in their request for evidence. They want a more detailed job description. But I always start with what I originally submitted to make it clear to the officer that I'm not modifying the job or changing it or adding anything to it. I'm just expanding on what was already there.
Emily, Raj Potluri from YouTube has an interesting question. This is about the LinkedIn job experience he's speaking about. He's speaking about in the LinkedIn, when he is going for a new project, they always want to look into what kind of previous projects he has done. So by limiting the company that is listed as an employer there, where he cannot list as an end client, it's going to be a problem for him when he wants to get new projects.
Well, I think you can get the same information in LinkedIn without listing that client as your employer. You can list your actual employer and the dates you've worked there, and underneath it, it gives you the option to add job
The
duties
projects.
or talk about the projects you worked on. And you can certainly list the end clients there if you were authorized to work there. So I think it's just a matter of changing how you're providing the information so that you're not giving the wrong impression.
So Raj, I would suggest you to list your employer, let's say ABC Consulting Inc., as an employer, and then list the projects in there separately. Saying, let's say, for example, you work for Pepsi or you work for AT&T, you list them separately. Don't list them as an employers, list them as a projects, but don't list them as an employers.
Nimish from YouTube has a question about the H-4 EAD litigation. So if you're aware, the Department of Homeland Security filed a response to the court yesterday explaining why they think that oral arguments should be put on hold, because that was supposed to be happening at the end of September. And DHS responded basically saying that the earliest they can expect a rule or a regulation is spring 2020, and that's kind of they said an aspirational timeline. So that's the best case scenario, the very earliest they could get out this regulation, which means that it's likely going to take longer than that. And so Nimish's question is, does that mean that H-4 EAD is going to be revoked in March of 2020? It means that the earliest we may see a final regulation that takes effect is spring 2020. That final regulation is intended to eliminate the H-4 EAD. Does that mean existing H-4 EADs are revoked? We don't think so. We don't know. We won't know until we actually see a regulation. But number one, remember this is the fastest it's possibly going to happen. And more importantly, I'm a lawyer and I can never guarantee anything, but this is the one thing I can almost guarantee is there will be lawsuits when DHS does finally publish that rule. So it's very likely that even if that's what they're intending is to eliminate it in spring of 2020, will that actually happen? Probably not. I think that it's very likely that it'll lead to another court battle, and it might stay in place during the court battle, which this court battle has been already going on for 2 years.
Good question. Ramakrishna from YouTube has, his son is in the Boy Scout. Can I volunteer position in the Boy Scout committee? You can, absolutely, that's not a problem. It is considered as a completely voluntary jobs are fine. If you're expecting anything in return, financially or a future job in there, that is not considered as a volunteer job. And I don't think so. You volunteering in the Boy Scout committee, you are expecting any jobs in the Boy Scouts committee, and that's objectively nobody is going to think that you are expecting a job there, and you're not expecting any money to come from there. You are perfectly fine to work to volunteer as a position of the Boy Scout committee, especially when your son is in the Boy Scout.
Question about social media. This is from YouTube, what particular social media activities could cause an issue for H-1B stamping? So we kind of already mentioned that the way your job experience is listed on LinkedIn could be an issue, or your marital history could be an issue. But a lot of people want to know, what about, what if I'm commenting in a bad way about the president on my Facebook page, or what if I post a comment on LinkedIn, or what if I'm watching videos that are anti-Trump or something like that on YouTube? I don't think that is what they're intending to catch when they're adjudicating your visa application at the consulate. When they created this, this provision where they can ask for the social media information, it was specifically under an executive order dealing with national security. They're looking for terrorist ties.
Like, let's say, for example, if you're a fan of ISIS organization, which is doing all bad things in Syria and Iraq, yeah, definitely you'll be in trouble. But if you are politically, veering on one side, another side, we don't see any problem in it at all. Whether it's a Democratic or Republican, we don't see any problem in it. The question comes from Sriram Srinivasan, is that in the CBS News, they said that you can cite the Fourth Amendment by not sharing the WhatsApp information. Well, that may be true for US citizens, but it definitely might not work for the non-immigrant visa applicants into this country. So Sriram, if you're expecting the WhatsApp to be completely safe, you're coming into it, no, don't do that. You have very limited Fourth Amendment, especially when you are traveling into the country through an international travel, and especially when you're a non-immigrant.
Yeah, I think the thing to, I guess, keep in the back of your mind is until you've exited the port of entry at the airport, you're not in the U.S. yet. You don't have any rights because you're not in America. Even though you're on American soil at the airport, until you've actually been admitted, you're not, you don't have as many rights at that point. Vamsi from YouTube wants to know if a Canadian citizen who's on a TN visa can own a business in the United States. The TN also, when you're on a TN visa, you're only authorized to work for the employer that sponsored your TN. So if your business is separate from that, I think that could be a violation of status. But definitely speak to an immigration attorney about the specifics of that business to make sure that it's not going to be a violation of status, because it very well could be.
Warren from YouTube has this question. He applied in the lottery and he got a very short-term approval. Does he have a chance of suing the USCIS? Warren, yes, you do. We started suing USCIS on the short-term approvals. You may want to join our group litigation. However, the only issue is that your employer has to join for the group litigation for the lawsuit. When the USCIS is denying, when your company is applying for 3 years, they're only giving for 6 months or 1 year. It's a complete violation of the Administrative Practices Act, because when they do that short-term approvals, they're supposed to explain why they are doing the short-term explanation, why they're giving short-term. And absolutely USCIS is not doing in 99.9% of the cases. So you can sue. I mean, it's an easy victory we're expected to get when we go to the court. We already sued USCIS. We're expecting results pretty soon. Also on the denials, also on the quota, H-1B quota denials, we strongly recommend that you go through the litigation process rather than actually going to the appeal or motion to reconsider. Appeal and motion to reconsider, if you go through it, the percentage of success rate is only 3%. You go to the litigation, you go to the court, you explain to the things, you have a very good chance of approval. Especially the denials that are coming because the employer-employee relationship, the USCIS is completely violating their own regulations because it's either hire, fire, and pay. These are the 3 requirements that that need to be there for an employer, which they're not even questioning whether your employer has the authority to hire, fire, and pay. They're asking and or otherwise control. So, sorry, it's hire, fire, and pay or otherwise control. It's not and or, it's or otherwise control. So they're going directly to the or and interpreting it as and. It's not end according to the regulations, it's not end even according to the memo that they have issued. But when their interpretations are coming, it is hire, fire, pay, and otherwise control. That and otherwise control is actually violation of their own regulations. So if you go to the last court, which is where the judges are appointed and ratified by the Senate, we do have a good chances for us to get the approval there, rather than going to the litigation process. Normally, when we are filing these court cases, though, what's happening is that it doesn't go to the full hearing because the USCIS doesn't want to get a negative result in the court. That's going to affect the entire H-1B application. What they're doing is they're just reopening the application, they're just approving those applications, and then telling us to drop the case, and we have nothing there to fight. I mean, we got our case approved, so we're dropping the cases. So we strongly recommend to go to the litigation if you have a short-term approval or if you're denied in the H-1B quota.
Ram from Facebook wants to know about L2 EADs. So he's in the similar situation that we've talked about as the H1 and H4 and H4 EADs. Already received his L1 extension approval, but his wife's L2 and EAD were filed way back in June and are still pending. Her status is going to expire October 9th and wants to know what options there are for expediting. Ron, the only thing that we've found that actually works is filing a lawsuit. We've joined multiple plaintiffs together many times. We've been filing every 2 weeks, and we filed the lawsuit stating that USCIS is not following the Administrative Procedures Act, which requires them to finish a matter in a reasonable period of time. According to Congress, they expect that non-immigrant visa applications should be finished within 30 days. That's what they consider to be a reasonable period of time. So if the L2 and the EAD are still pending after 30 days, you can join in that lawsuit and compel USCIS to approve the L2 and the EAD. Typically, we see that done within 60 days of filing the lawsuit.
Gurpreet has this question from YouTube. Can he file an exempt H-1B if he's working for a for-profit company, but he's going to be working with a university, which is a non-profit organization? Yes, under limited circumstances, if you're working for the end client is a non-profit university, and even though your company is for-profit, you can file an exempt H-1B. And you can do it right now. You don't have to wait until April 1st to file this application.
Anand from Facebook wants to know if receiving a 1.5-year approval of an H-1B can be considered a short-term approval. So assuming that the 1.5 years isn't due to your 6-year limit, absolutely, that's a short-term approval. Most likely we would expect that your employer asked for 3 years. So when they approve for anything less than 3 years, it's basically a partial denial. They've approved your 1.5 years and they've denied the other 1.5 years, yet they never give a decision why they're denying that other 1.5 years, and that's a violation of the Administrative Procedures Act as well. So absolutely, and that's the better situation in which to join this litigation is, when we talk about short-term approval, if you've been approved for a day, which we've seen, or 3 months, that might not provide enough time for the litigation to work. But if you've got a short-term approval that's only 6 months or a year or a year and a half, that gives enough time to file the lawsuit, have the USCIS respond, or get to the 60-day limit where the attorney has to respond to the lawsuit, and so you're likely to prevail in that situation.
The question came from Rajesh from YouTube is that the H-4 EAD has been pending for more than 5 months. Can we raise a service request to expedite it? Rajesh, they are not taking the service request for Expedite anymore. My suggestion is to go through the litigation process. Reddy Neumann PC does file litigation every 2 weeks. We've been very successful in that. You may contact us to do it. We have had pending H-4 EADs for a long period of time, including 1 year. The best way is to go through litigation. What we suggest people is that don't wait for 5 months. They're not adjudicating the H-4 EADs. As soon as you file, I would recommend to contact the litigation lawyers, and our law firm does that. Don't wait for 4 or 5 months. As soon as you file, come over. We will give you a path for litigation, tell you how much time it's going to take, and then you can take it. Otherwise, don't wait for 6 months and you come to the litigation. Maybe you can get the approval probably naturally rather than actually going to the litigation. The best cases for the litigation to file in the court is when you actually come within after 1 month period that you file the H-4 EAD. The basis for the litigation is that we are not going based on the USCIS website saying how much time it's taking for them to approve. We're going with the Congress. The Congress intended USCIS to adjudicate these applications in 30 days. And what we're basing the court case is that, look, you're supposed to adjudicate the case in 30 days, and you have not adjudicated. You went to the Office of Management and Budget. You told that the filing fees that you are collecting is enough to adjudicate the H-4 and EAD application. The amount of time you said in the Office of Management and Budget, it's going to take between 15 to 20 minutes to adjudicate the H-4 and 15 to 20 minutes to adjudicate the H-4 EAD. And that money that is being given to you is sufficient for you to adjudicate the case. And when we are basing our litigation, what we are telling is that, look, they're supposed to adjudicate 30 days. They told the money is enough. They told the timing, and they are violating everything what they are telling. We request them to adjudicate. And what happens is that once we file the court litigation, before their time of maturity where they need to respond, they're just adjudicating all the H-4 approvals, and then they're coming us, drop the case, because you have nothing else, all your cases get approved, and we end up dropping the case.
Vivek from YouTube wants to know what the timeline is for L1 and L2 extensions at the Texas Service Center. They filed in August and everything's still pending. So you can actually view the normal processing times by going to uscis.gov. You can select processing times, and then there's a drop-down menu where you select your case type, which was going to be an I-539 if you're wanting to know when the L2 might be approved, and then you select the service center that yours is pending at, and it will tell you exactly how many months it should take for them to process. But those are generally quite long. I don't know Texas off the top of my head, but I want to guess it's probably in the 3 to 6 month range. So if you filed in August, you've still got several more months to wait to get that.
Yeah, that's for L1 though. L2s are taking much longer. They used to be adjudicated along with the L1s. They are not getting adjudicated along with the L1s now because the fingerprint rule came in. One question that came in is that I filed my I-140 application. Can I travel to India? Will that cause any problem in getting the H-1B stamping? No, it doesn't cause any problem whatsoever at all that your I-140 is pending or your I-140 is approved. It doesn't give you any advantage. It doesn't give you any disadvantage in getting the stamping.
Rajesh from YouTube's wife came to the U.S. on H-4, and after she got here, she applied for the H-4 EAD that's been stuck in case was received for 5 months on the online case status. He wants to know if you can put in a service request to expedite it. Well, the service request, they'll only take it if it's outside the normal processing time. So that's where you go to that website, uscis.gov, find the I-765, and then select the service center where it's pending at. They actually list a date, and if yours was filed after that date, they won't even take a service request. Now you can call customer service and do an expedite request, and they'll take down your information after you sit on hold for 2 or 3 hours, and immediately 10 minutes after your call or within 24 hours of your call, you will get an email saying we've denied your expedite request, with no explanation at all other than it doesn't meet our criteria for expedite requests. I mean, we've tried so many times. We've had people who were losing their jobs, whose kids, U.S. citizen kids, were going to lose their health insurance because they're on their parents' insurance. I mean, people losing their driver's license, physicians who had surgery scheduled, they couldn't do the surgery, physical therapists that are the only physical therapists at a skilled nursing facility, they're going to lose their job. They can't treat their patients that are U.S. citizens. Nothing seems to matter. They don't expedite anything. So again, litigation is the only thing we found that works.
Nimish has this question that on the H4 EAD, if you file initially H1, H4 and EAD and then try to convert into premium processing later on, will the H4 EAD gets approved? Yeah, we suggested this trick a long time ago on the YouTube because we didn't have any other alternative methods at that point of time. Nimish, that did not work in a single case at this point of time. So after fingerprints, they converted to premium processing. That did not work, unfortunately. So that's the reason Reddy and Neumann PC is just filing lawsuits every 2 weeks. That's the only way that we think so that's eligible for.
Septarshi from YouTube wants to know if I apply for an H-1B to H-4 change of status, when does the status actually change? Is it at the time you file or at the time of approval? That's a really good question. So just because you filed the change of status doesn't mean you have to move to H-4 immediately. If you are in H-1B, for example, and you want to continue working for some time and you're going to continue working for your H-1B employer under the terms and conditions set, you can do that the whole time the H-4 change of status is pending, and then when the H-4 is approved, that's when you enter H-4 status. You can also do the opposite. Say you want to stop working tomorrow, even though your H-1B is valid for another year, and you file your H-4 change of status tomorrow. You're not in H-4 status yet, but you're also not in H-1B status anymore because you've stopped working. In that situation, you're in a period of authorized stay that allows you to remain in the U.S., and your change of status will be approved. Once your change of status is approved, then the H-4 status will actually kick in.
How long does it take for a spouse to get the green card if the main applicant is a green card holder? Assuming that your spouse is already in United States, it's going to take anywhere between 2 to 4 years, depending on the priority date. The priority date in August of 2019 was current for the green card spouses. Now it's backlogged. So depending on the timing when you file the application, when you got married, it may vary any time between 2 years to 4 years.
Shanmugh from YouTube works at a third-party site, so working at an end client and is planning to go for stamping next spring and sees that a lot of people are getting stuck with this administrative processing or getting delayed and wants to know how risky it is. It is definitely a risk. If you don't have to go, I would not recommend it, especially when you're in that situation where it's third-party placement. There's a lot of extra processing that the consulates do. They do additional fraud detection work. So while you're sitting and waiting for your visa approval, they're going to be contacting the end client and asking them, hey, can you confirm, does this guy still have a job offer at your location? And hey, here's a copy of the letter he provided to us at the consulate. Does this match what you actually wrote? Was this an authorized letter? They might contact your employer to verify that they are a legitimate employer and that the employer-employee relationship does exist. All of those contacts and checking into things takes time. And so even if everything is perfect in your case and you've dotted all your I's, you've crossed all your T's, you have the job, you're ready to go, you might be stuck for several weeks just for that processing to be done. And by the time it's over, you could lose the job. So it is a huge risk.
Emily, I want attention on Ashutosh's question on the YouTube. We are telling that there is a misinterpretation by the USCIS, and this misinterpretation wrong interpretation by USCIS is universal. I mean, it's not like one officer doing it. There must be an explicit instructions to follow it differently. So what is the authority that they use when they deny it is the question that he is asking.
They just misquote the regulation. They say that you have not proven that you've have the authority to hire, fire, pay, and control. They totally changed the word. I mean,
but there are a couple of other intellectual discussions. Is that on the February 22nd of 2018, Ashutosh did issue a memo. That memo by itself is completely misinterpreting the entire regulations that they have. Even within that memo is internally inconsistent. It's contradicting its own memo within. You don't have to go outside the memo when you read the February 22nd memo. Having said that, there are also, Ashutosh, is that from the time Trump administration comes in to right now, there is no law that is changed. There is no regulation that is changed except the new lottery system that came from April 1st of 2020. There is no regulation that came in changing any of the regulations. Yet, when you look into the denials, Ashutosh, look into it, the denials used to be 5 to 7% to about 25 to 40% right now. Without changing any rules, without changing any law, the denials have gone 4 to 5 years. Now, previous denials, most of the 5 to 7% were people that were filing with were completely not eligible. There were very less where lawyers were filing with all the details. We used to have 2% denial rating in our office. Can we claim the same thing? I mean, our office used to see monthly 1 to 2 denial or 3 to 4 denials. Well, right now we are seeing it every day. So this is a complete wrong interpretation by the USCIS. How come they didn't interpret it that way? They are intentionally doing it. Now the question is that, is there any authority that they are doing? Well, let me tell you the authority. Simple. It's Trump, Trump. That's it. The administration wants to force these officers to look one way, and they are look the other way, and they are looking the other way. That's all it is.
Addie from YouTube has an I-140 that's been approved for more than 180 days and is thinking of moving to Canada temporarily. Wants to know if the green card process can continue if the priority date is current. Well, if you still intend to join that employer that sponsored you for that I-140 and that employer still has the job open for you, yes, you can continue your green card process when the date is current. If you're still in Canada, the process can be done through the consulate so that you can receive your green card there and come into the U.S. to work for that employer.
The question that comes on the STEM OPT, is there a minimum pay, Emily, that is required in STEM extension period of time? will there be any problem if the pay is very low?
Yeah, there is a minimum. There's not a specific number. The pay for a STEM OPT worker has to be commensurate with what the employer would pay other U.S. workers doing that same job. So if the company is paying a U.S. worker $60,000 a year for the work you're doing, and they're only paying you $20,000, that's a violation of the STEM OPT requirements from the employer. And yes, you have to work a minimum of 20 hours per week when you're on your STEM OPT. So being paid less one month and more another month could lead a USCIS officer to conclude maybe you're working less than full time. So there's a lot of risk involved in not following the STEM OPT requirements there.
What is the minimum period of time you need to wait for filing the H4EAD litigation? This question comes from YouTube. You have to wait for 30 days for you to file the litigation. The reason why you have to wait for 30 days is that even we know that they are not going to adjudicate in 30 days is that legally they are supposed to adjudicate in 30 days. So if you file a litigation on 29th day, the judge is not going to be happy with us and we can't file a litigation. The question comes to, are you getting any approvals? Yeah, every case that we file is getting approved before their response time. There are only 2 cases where the USCIS has requested us permission for 60 days to respond beyond the time period that is being given by the court. But we said we are going to only give them 30 days. And we took them and they promised us they're going to adjudicate as fast as possible. Just for the court's sake, we gave them 30 days. It turns out that within 3 days after we gave them permission, they gave the approvals. And once those approvals come in, we are dropping those cases.
Vivek from YouTube has questions about the L1 7-year limit. Wants to know, is there any way to stay in the U.S. after the 7 years without applying for the green card? There is no extension beyond the 7-year limit for L1s, even if you have the green card. That's only H1s that allows for that. So your only option is to change status to another type of visa that you might qualify for. The H-1B would not be an option if you've used up your 7 years in L1, because L1 time does count towards the H-1B limit as well. But as far as you do have the option of recapturing any time you've spent outside the U.S. So if during those 7 years you've taken several months trips every year, then you can recapture that time. And the counting starts when you enter the U.S. in L1 status, or if you're changing status, the day your change of status takes effect. That's when you start counting your 7 years, not from the visa issuance.
The question that comes from Miriam is that her I-140 is approved, her 485 has been filed for more than 6 months. Can she now change to a different employer? Miriam, yes, you can. You need to file something called 485J supplement. And when you're moving from one company to another company, the new company's job should be in the same profession. So if you're in the software profession, you want to move to mechanical engineering, you can't. You still have to move to software profession. No problem with that. The question that comes up is that I'm on the 2nd year of master's student here in United States. Once I do the master's degree, when I apply for the green card, how long it's going to take for me to get the green card? This gentleman is from India. Sir, you're not going to get the green card because the waiting period for the green card is going to be way, way higher. Though it says that the waiting period is only 10 years for the EB2 and EB3 to get the green card. But let me tell you one thing, in 2012, the waiting period was 2010. And after 7 years, the waiting period still is the same. So what does that tell is that the waiting period is going to increase as it goes on. There are some good articles written on rnlawgroup.com. It's called 108.6 years. That's the word that you can research. That's a time that we have said it's going to take for you to get the green card if you were to apply in February of 2018. There are some statistics that we put in there and the governmental links that are there where how many number of people are waiting for the green card is given there.
Praveen has an I-140 approved and has changed employers after that and wants to know how soon does the new employer need to start the green card process so I don't lose my priority date. Well, if your I-140 has been approved for at least 6 months and your employer did not withdraw it before that, you get to keep your priority date, and the new employer does not have to start the process right away. You can continue extending your current status based on the old employer's approval notice. You can transfer to another employer and continue to extend. When you do need to have the process started is by the time your date is actually current, you have to have a new labor and a new I-140 in process so that you can file your 485 at that point. But up until that point, you don't need to have the new employer file the PERM or I-140.
Another question that comes from YouTube on the I-140 is that I have moved to the new company, but my I-140 has been withdrawn. But before it's been withdrawn, it was been approved for more than 180 days. Can my wife use that I-140 to apply for an EAD? Yes, even though it's been withdrawn after 180 days of approval, you can use that to file for your wife's EAD. Absolutely not a problem.
Rhea from YouTube has a question about when you file an H-1B transfer, does USCIS compare the job duties of the new employer to previous job duties they've held in the past? And the answer is no. They are not, because the H-1B is based on your education, not experience. It's for a position that requires at least a bachelor's degree in a specific field of study. So as long as your new position requires a bachelor's degree in a specific field of study and you have that bachelor's degree, you qualify. That's enough. You don't have to also prove that you have experience in that particular field or doing those job duties in the past. That could be more relevant to labor certification and I-140, but not to H-1B.
Raj Gopal has this question that the H-4 visa has been approved in the consulate, and his wife wants, can she apply for the H-4 EAD because he has I-140 approval even if she is not within United States? No, she has to be in United States at the time your wife applies for the H-4 EAD. However, you can do one thing. Since she has a visa, or she can come here, apply for the H-4 EAD, then she can travel, and the EAD will be adjudicated without any problem. Now, this is only the case where I'm telling you have applied for EAD. This is not applicable if a person applies for H-4 plus EAD. This is only when the EAD is applied. So you can have your wife fly in, apply for the EAD, and then travel back. I know a lot of people, they have employment opportunities back in their home country, they don't want to leave it, so have her come, fly, apply the EAD, then fly back.
I think we have time for one more question. Ranjit from YouTube wants to know if the H-1B is filed by the company's attorney, can a different attorney handle the litigation if there's a denial or a short-term approval? And the answer is yes. The litigation can be done by a different attorney. We've a lot of the cases we've been filing, most of them in fact, were not actually filed by our firm. No issues with that at all.
And we do file about between 25 to 50 litigation cases every week from our office for H-4 EADs, H-1s, and other things.
All right, well, I think that's about it for today. Thank you for joining us. If we were not able to get to your question, you can always join our daily conference call. You can find the login information for that and the schedule at rnlawgroup.com. If you would like to talk about your situation in more detail and get some specific advice on your situation, you can set up a consultation with either of us or any of our other attorneys in our office, but also by going to rnlawgroup.com. You can select your attorney and pick a time that works with your schedule there. Please check out immigrationgirl.com as well for the latest updates. I posted a blog post today about what's going on with the H-4 EAD litigation and what happened in the court yesterday on that. And I think that's about it.
Thank you guys for coming in.